Can we hear me, please?
Yes, sir.
Good afternoon, sir. Yes, sir.
Good evening, everyone. Thank you very much for joining the meeting. Good evening, Mr. Ebenezer Igwatu. I can see our mentor is on the call. Good evening, everyone, and welcome to the week 4 of Gypsy Mentorship and Internship Program on Health Tech and Law. And our topic for today is healthcare transactions and contracts. And we're having our mentor with us today, Mr. Ebenezer Igwatu. Our profound mentor, I believe we all know about him now. So I don't think there will be a need to read his profile. Mr. Ebenezer, kindly indicate if you're on the call. So I can see that you are unmuted, but I can't hear you. Hello, everyone. Can we hear me?
Yes, sir.
Can we hear me?
Yes, we can hear you. However, there is an echo.
Okay, sir. I think the floor is yours to give us an overview on the topic, sir.
Okay, good evening, everyone.
Sir, we can't see you on the screen. We can't see your video.
Can you hear me?
Yeah, yes, we can hear you, sir. But we can't see your screen.
Okay. Can you hear me?
Yes, loud and clear. We can see you now.
Okay, good evening, everyone. I believe we have had a restful weekend. I know within the week we might have one or two engagements, but starting from Friday evening, yesterday, and up to now, I want to believe we have had a restful weekend, and we are in good spirits for today's class. Over the week, I was supposed to make an input on the slides when it was sent to me. However, I was a bit under the weather and couldn't do anything. But after the presentation today, I will make my comments as we see fit. I noticed that 2 of the slides are blank, but it's showing whenever I put them on. No wahala. We'll find a way around it. Today we are discussing healthcare contracts and transactions. You know, we are dealing with medical law, health and tech law, so to speak. Today we are discussing healthcare contracts and transactions. What are healthcare contracts? Those are the things we will be looking at. What are healthcare transactions? Which parties are involved in healthcare transaction or contract? In the event of breach, are there remedies available to both or either of the parties, or the party who feels that his or her rights or terms of the contract or entitlement in the contract is being denied? Those are what I look out to see this evening. In order not to waste our time, so that we don't end up repeating ourselves, I would like to hand over the floor or yield the mic to the coordinator to bring up the presenter for today, and we'll take it up from there. Thank you very much.
Thank you very much, Mr. Ebenezer. Presenter for today, please, if you're on the call, you can unmute yourself. Our presenter is Mercy. I can see Mercy on the call, so It's over to you, Mercy. Kindly unmute yourself, share your screen, and start your presentation.
Yes, sir.
Thank you.
Good evening, everyone. My name is Oladende Messi, and I'm the presenter for this week, and I'll be presenting this week's topic on behalf of my group. The topic of today's presentation is healthcare contracts and transactions. In the course of this presentation, I'll touch on various aspects of this topic, such as the basic elements of a contract, classes of healthcare contracts, common challenges when conducting healthcare transactions, and other subtopics are seen on the screen that can help us gain an in-depth understanding of this topic. So the question now is, what is a healthcare contract? Well, in simple terms, a healthcare contract is a regular contract on healthcare-related issues. In essence, it is a legally binding agreement between healthcare providers, such as hospitals, clinics, doctors, and other parties, such as patients and healthcare organizations. Healthcare contracts can arise in different forms. These include medical service contracts, vendor contracts, and managed care contracts. In the course of this presentation, I'll go into detail on how each of these contracts work. Although healthcare contracts come in various forms, they all have one underlying aim, which is to ensure clarity, protection, and compliance in the delivery of healthcare services. Now we'll talk about the basic elements of a healthcare contract. Like I said earlier, a healthcare contract is a variant of a regular contract. This means that all the basic elements required in a legally binding contract must be present in a healthcare contract. These elements include offer, acceptance, consideration, and legal capacity. Now let's discuss each of these elements. Offer. An offer is a proposal made by one party, the offerer, to another party, the offeree, indicating their willingness to enter into a contract on specific terms. The offer must be clear, definite, and communicated to the offeree with the intention of creating a legal obligation upon acceptance. Now, acceptance. Acceptance is the unqualified and unequivocal expression of the offeree's agreement to the terms of the offer. While consideration, on the other hand, is a thing of value, which is exchanged between the parties pursuant to the contract. It is not restricted to money, and it includes acts, services, and property. Finally, legal capacity refers to a person's legal ability to enter into a binding contract and to be held accountable for their actions. Not everyone in society has the legal capacity to contract. For instance, in Nigeria, minors, mentally incapacitated persons, as well as intoxicated persons have limited capacity to contract. Aside the basic elements required to make a healthcare contract legally binding, there are also certain terms that need to be included in order to protect the rights of the parties. These terms include the scope of service, the payment term, confidentiality, termination of contract, and mode of dispute resolution. Now we're going to discuss each of these terms in detail. The first term to be considered is the scope of service. As indicated by the word scope, this involves outlining the range of services to be provided by the healthcare provider to the other party. And it is very important to be as specific as possible when itemizing the scope of service, because in the event of a dispute, this is actually what will be used to discern the contractual obligations of both parties. The next term is payment term. This term specifies the mode of payment. It could be by cash or a check, the time of payment, the payment schedule, whether instrumental or all at once, as well as the penalties for late payment or no payment. Like the scope of service, it must be clear and unambiguous. Next up is the confidentiality term. A confidentiality term in a healthcare contract is basically a provision that addresses the protection of sensitive and confidential information that are shared between the parties involved in the contract. Now, this clause is particularly important in healthcare contracts because they often involve the exchange of sensitive information, such as patient information, emerging medical technology, and research data. And the confidentiality term sets out the responsibilities and obligations of each party so as to maintain the confidentiality of disclosed information. Then another term is the termination clause. This one outlines the specific circumstances under which the parties may terminate the healthcare contract, and it helps to prevent either party from arbitrarily terminating the contract for people reasons. So it prevents a situation whereby one party just arbitrarily terminates the contract for no reason. Then there is also provision for dispute resolution. A dispute resolution term in a contract outlines the procedures and mechanisms that the parties will follow to resolve any disagreements, conflicts, or disputes that may arise during the course of the contract. And this is essential because it helps prevent costly and time-consuming litigation by providing a structured approach to resolving issues in a more efficient and amicable manner. I said earlier that healthcare contracts have various forms depending on the service being provided. And these forms include medical service contracts, vendor contracts, employment contracts, and managed care contracts. Now, what are each of these contracts and what do they entail? The first contract mentioned is medical service contracts. Medical service contracts are specific types of healthcare contracts that outline the terms and conditions under which medical services will be provided to patients or clients. So these contracts are typically agreements between healthcare providers such as doctors, hospitals, clinics, or medical practices. And then the other party, which are the patients, insurance companies, government agencies, or other entities that are responsible for paying for or receiving medical services. These services include medical treatments, laboratory services, consultations, and diagnostic tests. The primary aim of a medical service contract is to protect the rights and interests of the healthcare provider and the patient or the party receiving medical services. Then we have vendor contracts. Vendor contracts in healthcare refer to agreements between healthcare organizations such as hospitals or clinics, and then external vendors who provide goods or services necessary for the operation of the healthcare facility. These contracts outline the terms and conditions under which the vendor's products or services will be supplied, the pricing and payment arrangements, and the responsibilities of both parties. The primary goal of such contracts is to ensure that the healthcare organization receives the necessary supplies or services as agreed in order to facilitate the smooth and effective functioning of the healthcare service. We also have employment contracts. Employment contracts in healthcare are legally binding agreements between healthcare providers and then healthcare organizations. These contracts outline the terms and conditions of the employment relationship, including the rights and responsibilities of both the employer and the employee. And why are employment contracts necessary? They are necessary because they establish clear expectations, protecting the rights of both the employer and the employee, and promotes a positive working relationship. They also help to ensure that the employment relationship is legally compliant, transparent, and fair to all parties involved. It is noteworthy that healthcare professionals must carefully review and understand the terms of their employment contract before accepting a job offer. Then lastly, we have managed care contracts. Managed care contracts are agreements between healthcare providers, hospitals, physicians, and the likes, and health insurance companies. These contracts establish the terms and conditions under which healthcare providers will deliver medical services to the members or beneficiaries of managed care plans. So the primary goal of managed care contracts is to create a network of healthcare providers who agree to offer services to members of those plans at negotiated rates. So this ensures that people who subscribe to these managed care plans have access to a comprehensive range of healthcare services at more affordable cost. So a classic example is that of the health insurance plan that many Nigerians are now dabbling into today. Now, importance of compliance with the terms of the healthcare contract. Compliance with healthcare contracts is of utmost importance for several key reasons, as outlined in the slide. Healthcare contracts, like any other legally binding agreement, establish the terms and conditions under which healthcare services are provided. So they set the expectations for all the parties involved. Ensuring compliance with this contract is crucial for the smooth and effective operation of healthcare services and for protecting the interests of all parties. We also ensure that the contract is legally enforceable, the parties are protected, and help to prevent disputes and misunderstandings. Now, for laws and bodies that regulate healthcare contracts, Nigeria has a framework in place for regulating healthcare contracts. This framework includes bodies and statutory provisions that ensure that the rights of parties to healthcare contracts are protected. We have the Federal Ministry of Health. The Federal Ministry of Health is the primary government agency responsible for formulating and implementing healthcare policies and regulations at the federal level in Nigeria. So they play a significant role in overseeing the healthcare sector, and they are also involved in regulating healthcare contracts, especially those involving public healthcare facilities. State ministries of health. Each state in Nigeria also has its own Ministry of Health, responsible for implementing healthcare policies and regulations within their respective states. They regulate healthcare contracts, especially those involving state-owned or operated or state-operated healthcare facilities. Then another body is the Nigerian Medical and Dental Council. The Nigerian Medical and Dental Council is a regulatory body responsible for the registration and regulation of medical and dental practitioners in Nigeria. They ensure that healthcare providers adhere to professional standards and ethics in their practice. This includes ensuring that healthcare contracts are professional and ethical. We also have certain statutes that regulate healthcare contracts. This includes the Code of Medical Ethics in Nigeria. The Code of Medical Ethics in Nigeria are a set of guidelines and principles issued by the medical and dental practitioners, the Medical and Dental Council of Nigeria, rather, to regulate the conduct of medical and dental practitioners in the country. So this code outlines the ethical standards and professional responsibilities that healthcare providers are expected to adhere to in their practice. Now, while the code primarily focuses on ethical guidelines rather than contractual issues, healthcare professionals and organizations may choose to incorporate these ethical principles in their contracts in order to reinforce the importance of ethical conduct and professional standards in their working relationship. Another statutory provision is the National Health Insurance Act. This act is instrumental in shaping healthcare contracts within the health insurance context in Nigeria. It ensures that healthcare services are delivered efficiently and cost-effectively to those that are enrolled under the insurance system. Now, compliance with this act is essential for all stakeholders in the health insurance system to promote transparency, accountability, and access to quality healthcare services for Nigerians. Then we also have the Nigerian Medical and Dental Practitioners Act, which primarily focuses on the regulation of medical and dental practitioners in Nigeria. And while this act does not directly regulate healthcare contracts in the traditional sense of contracts law, which regulates contracts primarily, it plays an essential role in shaping the conduct of healthcare professionals and their relationship with patients and other healthcare providers. So this in turn can indirectly impact healthcare contracts. Now, there are certain challenges that come on when conducting healthcare transactions or making healthcare contracts, and we have them. First is unclear or ambiguous terms in a contract. Unclear terms or ambiguous language causes the contract to be open to multiple interpretations, leading to different understandings of the contract provisions by the parties. And we have a situation where there are conflicting expectations and disagreements on what each party is obligated to do under the contract. Then we also have the issue of lack of clarity. Lack of clarity creates a situation where the contract fails to provide sufficient detail or specificity regarding important aspects of the contract, such as the scope of services, the payment terms, and other important terms. So this creates uncertainty and makes it challenging for the parties to know precisely what is expected of them. There's also the issue of lack of adequate communication. This poses significant challenges to healthcare contracts, as effective communication is crucial for ensuring that all parties understand their roles, responsibilities, and obligations under the contract. When there is insufficient communication, it can lead to misunderstandings and different interpretations of the terms and contracts, a classic recipe for disputes. Then we also have payment disputes. Payment disputes are problematic because they can result in delayed or withheld payments to healthcare providers. This can result in financial strain for the provider, impacting their ability to cover the cost of operating their healthcare service, paying staff, or even investing in resources for patient care. And in some cases, payment disputes actually lead to suspension or termination of healthcare services until the payment issue is resolved. And this can be detrimental to the health of the patient. Then, last challenge stated here is non-compliance with regulatory and legal requirements. Healthcare contracts are subject to various laws, as we have examined earlier, regulations, and industry standards that govern the delivery of healthcare services. So failure to comply with these requirements can lead to serious consequences for the parties, such as jeopardizing the effectiveness and validity of the contract. Having considered the challenges faced in healthcare contracts and transactions, it is important to explore how these challenges can be mitigated. First off, the terms of the contract must be couched in clear and unambiguous terms to avoid misinterpretation. The scope of service must also be stated in specific detail so that each party is aware of the obligations under the contract. Also, payment terms must be included in the contract to avoid payment disputes, and both parties must ensure that the contract is compliant with legal and regulatory requirements. Elements to prove in breach of healthcare contracts and transactions. There are three elements that are required to prove a breach of a healthcare contract. The first is the existence of a valid contract. The existence of a valid contract. So the first and fundamental element is this, and it means that there must be a legally binding agreement that outlines the rights and obligations of each party. It can be written, oral, but it is important to note that written contracts are generally easier to prove in court. Then breach. The party claiming breach must demonstrate that the other party failed to fulfill their contractual obligations. So a breach involves showing that the healthcare provider will not deliver on the agreed upon services, or that they did not meet the standard of care required. Then damages must also be established. So the party claiming breach must have suffered damages as a result of the breach. And these damages could be economic, such as financial losses, or non-economic, such as pain and suffering. Now, what are the remedies available upon a breach of healthcare contracts and transactions? We have damages. Damages aim to put the injured party in the position they would have been had the breach not occurred. So this may include compensation for financial losses, such as additional medical expenses incurred due to the breach. Then another remedy is specific performance. Specific performance is an equitable remedy, and it requires the breaching party, that's the person who is in breach of the contract, to fulfill their contractual obligations as originally agreed. So it's important to note that specific performance is not a remedy that is granted in all cases, and this remedy may be sought only when the unique nature of the services makes it challenging to obtain equivalent services elsewhere. Now we have a case study here, the case of Henbury versus Farrow. So in this case, the court held that in certain situations, a patient may have the option to sue a medical service provider for breaking a promise or warranty that they made separately for regular medical treatment. So what the court held in this case is different from a regular medical malpractice lawsuit. So for instance, if a doctor promises a specific outcome or result from a treatment but fails to deliver it, Henbury versus Farrow is stating that the patient might have a legal claim based on the breach of that promise. So this claim is not about the quality of the medical treatment itself, but rather about the doctor not fulfilling a separate promise that they made. Then another case study here is the case of Healthcare Foundation of Greater Kansas versus Hospital Corporation of America. So basically, this is a dispute that arose between the Healthcare Foundation and the Hospital Corporation of America. So HCA for short. So the dispute arose because this HCA did not fulfill the promises that it made when it acquired a group of 12 hospitals from Health Midwest in 2003. So this foundation was created with money from the HCA Health Midwest deal, and they had the right to make sure HCA kept its promises because it was a contractual obligation. So the case went to trial, and the court held that the HCA should pay $434 million for not fulfilling its contractual obligations. Although the settlement was later reduced to $188 million, the case illustrates the consequences of breaching a healthcare contract, and in this case, it was damages. In conclusion, healthcare contracts are very important in today's society because healthcare is of utmost importance to the human existence. Transparency and clarity must be the watchword when it comes to healthcare contracts. It is crucial that both healthcare providers and receivers exercise due diligence, abstaining from misrepresentation and fraud. In the course of this presentation, we've also explored the vital role that regulations play in guiding healthcare services. These regulations are not mere guidelines to be left in isolation because they form the foundation of a safe and ethical healthcare environment. To uphold the trust of patients and the integrity of the industry, it is imperative to ensure that these regulations are not only established but diligently enforced. So when this is done, healthcare contracts will be effective in protecting the rights of parties involved. Thank you.
Thank you very much, Mercy, for that presentation on behalf of your group. Thank you very much. I will leave the floor to Mr. Ebenezer to step in from here.
Okay. That was a good attempt, Mercy. Kudos to you and your group. You practically took me back to my 200 level law of contract class. Well done. Okay, just a few things to point out. I expected a definition, or you are using terms that you are using some good contract terms or terminologies that required explanation or definition for a lay person who has not come in contact with law of contracts. Talk more of healthcare contracts. I expected a definition of terms like offer. Okay, you did that. Offer, parties to a contract specifically. I didn't see anything regarding to parties to a contract. Basically, there are minimum of 2 and many parties to contracts. But basically, when we talk about 2-party contracts, we are talking about an offer and offering. So when you say there is an offer, can you hear me? Please confirm. Hello.
Yes, sir.
Okay. Awesome.
Yes, sir. We
so
can hear you.
When you say there is an offer, who makes the offer? The offerer makes the offer. The offeree accepts. So that's definition of parties or telling us about parties to a contract is missing. Now, in this case, the healthcare service provider becomes the offerer, and the patient, if it is patient-doctor relationship, becomes the offeree. It could also be vice versa, that the patient becomes the offerer, where the patient goes to hospital and presents himself for treatment. When the doctor accepts that treatment, the patient is making an offer to be treated. If the doctor accepts that treatment, the doctor becomes the offeree. But if it is employment, the hospital management, the hospital makes, or the healthcare facility makes the offer to employ the healthcare service provider. Accepting that offer becomes the offeree.
Each time we talk about a discussion in respect of healthcare service providers have revolved around doctors and nurses. But I expected that you put the code of professional ethics of the respective healthcare service providers. So that captures doctors, nurses, radiographers or radiologists, lab technicians, anesthetists, and all the different disciplines that make up the healthcare service system. Then you also did not talk about terms of a contract. Yes, very, very key. You see, parties are bound to write whatever they like in a contract, provided that such terms are not offensive or repugnant to public policy, provided that such a contract or such terms are not, yes, I've said offensive, provided that such term is not a crime. So a party can say, I will work for you for 1 month, you pay 500 naira as salary. If it is okay and the parties accept it, fine, it will fly as contracts. Parties can also say, I will work for you for 1 month and you pay me 2 million naira. If both parties agree, so the parties must be at what we call consensus addendum, meaning both parties must agree to this term. That's why it is an agreement in the first place. So if there is no consensus between both parties, there is no contract, even if they signed it. Now, that means there could be fraud, which will make the contract unenforceable. There could be duress, which will make the contract unenforceable. There could be misrepresentation, which could make the contract unenforceable. But primarily, what parties should sign are things they have agreed to. Then, in this case, we are talking about healthcare contracts. So your offer and acceptance, consideration, and the capacity to contract were aptly captured the scope. Now, when you mentioning the scope, you said other elements, other terms essential in healthcare contracts. This is where you have what we call terms of the contract. In that terms, you will have commencement, which is the duration, when did the contract start. You now have duration for how many years was the length of the contract. Before you now talk about all these ones, scope of service, payments, confidentiality, yes, termination of contract, mode of dispute resolution. Then for healthcare, we will have a non-circumvention and non-disclosure, and we also have a full disclosure clause. If there are very key information that the employer needs to know, if you don't disclose them, which would have affected his engaging you, if you do not disclose them, for example, conflict of interest. If you do not disclose that is engaging you here, you have a similar business that does what he's doing, you have your own private clinic that will also be competing for your time and attention. So, and you enter the contract with them, you have breached the full disclosure requirements in that contract. So if you have your own clinic running, it is important that you disclose it to the other party, to the healthcare facility that wants to engage you, so that they will weigh and also know that we may not have this man available at all times. Then they will now decide, okay, regardless of this, we are willing to go ahead contracting with him. That is one. Then you also have non-circumvention. Very key. Now you could have a situation whereby the hospital engages a doctor for a particular treatment procedure. Then they have had a contract that for the next 4 or 5 years, you will be the one attending to our cardiac patients. Now, if the hospital now sees maybe a doctor of equal standing, but whose fees are cheaper, let's say the agreement for the first doctor with the hospital is for each patient he sees, he gets 100,000 naira. And they now see another doctor who wants to be taking 70,000 or 50,000 from them. The non-circumvention clause restricts the hospital from going behind this particular Dr. A to now go and engage Dr. B secretly. Dr. B comes, does what Dr. A ought to do, and the hospital pays Dr. B, even though they are saving 30,000 naira for themselves. Non-circumvention demands that you do not circumvent the other party to do something very important in the contract. So it can also be the other way around, that a patient who's supposed to come to the hospital, the doctor will not channel the patient to another hospital or direct or refer the patient to another healthcare facility and goes there to take the brief or, excuse me, and goes there to attend to the patient, thereby circumventing the hospital that originally engaged him for that purpose. So non-circumvention clause is very, very important. Then non-disclosure is also important, depending on what ought not to be disclosed. Particularly, even though the doctor, by reason of his being a doctor and professional training, he's already bound by the confidentiality principle by reason of having taken the Hippocratic oath to become a medical doctor. He is already bound. But for the purposes of contracts, healthcare contracts, the engaging or employing hospital might have the doctor sign a non-disclosure clause for them. Now, what it means is that whatever you see, whatever treatment you encounter in this hospital, whatever case you do in this hospital, starts and ends with you in this hospital. For example, if a patient comes in, maybe someone of note in the society comes in to run an HIV test and it turns out positive, and this doctor is the one taking care of that patient. The doctor is barred or restricted from going to town with that information that Mr. XYZ is suffering from HIV, even though the confidentiality code bans him already. But to further reinforce that, there is need to have a non-disclosure clause in that agreement that whatever healthcare service you render in this hospital is not for public consumption, because people's data are at stake, people's name are at stake, people's reputation and family. It is their healthcare status is part of their person, is part of their privacy. So non-disclosure comes in. Then on your remedies, legal remedies, available legal remedies to contracts, you mentioned only two. I want to agree with you in parts, but there are more. Before I get to remedies, let me talk about laws and bodies that regulate healthcare contracts. The bodies you listed here do not necessarily, to an extent, regulate healthcare contracts. Healthcare contract is strictly a legal issue. Now, Ministry of Health make policies, I agree, but they do not regulate. Ministry of Health does not tell doctors or hospitals what contracts to sign and what not to sign. National Health Act regulates to the extent that it provides for conducive environments to practice medicine, both on the part of the patient and the healthcare service provider. How do I mean? In the National Health Act, the rights of patients are stipulated. Now, when a patient enters, firstly, one of the sources of the rights of patients is what we call substantive law. Now, example, the law of contract. Once a patient enters into the hospital and the healthcare provider accepts or receives the patient and commence, a contract has been established. So, a person suing for patient's rights breach can be suing because he hello, people, confirm that you can hear me, please. Sorry, I had a phone call that interrupted. Confirm that you can hear me. Hello, can anyone hear me?
Yes, sir. We can hear you.
Yes,
Yes,
sir.
I
We can hear you,
Can
sir.
hear you.
Okay, sorry, I had a phone call that interrupted at the flow. Okay. healthcare practitioners. So to that extent, it provides what the doctor should want. Not that it regulates the contract itself. I don't know if you understand me. Now, the Medical and Dental Council, Medical and Dental Practitioners Act, it is the same. Because what the foundation practice of medicine in Nigeria. How we want to regulate healthcare contracts. Of course, perhaps out, yes, what should be penalties, don't do area. So, for example, euthanasia is a crime in Nigeria, basically. So if a hospital or a healthcare provider now goes into an agreement or a contract with the patient to help the patient carry out euthanasia services. Now, such contract is not a possibility, it is a crime because it's not operational in Nigeria, so it cannot be enforced. But the Medical and Dental Practitioners Act, but Nigeria Medical Practitioners Act was not Medical and Dental Council Nigeria, not Medical and Dental, does not also just go in line between healthcare professionals and healthcare practitioners and healthcare contracts. So, for example, Medical and Dental Council of Nigeria regulates the doctor, not the contract. So, if a doctor has signed the healthcare contract and the doctor does not now carry out his practice of medicine according to law, then the Medical and Dental Council comes in to punish the doctor, not to regulate the contract the doctor signs. Then, National Health Insurance Act, an extent, provides guidelines for both the patients and the services available to the patients by HMO. The HMO is not the intermediary. So it does not still regulate healthcare contracts, even though it provides guidelines on how people can subscribe or what subscribers or patients should do and how they can subscribe to the National Healthcare Scheme. Now, addition, we have National Health Insurance Authority Act, not National Health Insurance Act. Please take note of that. National Health Insurance Authority Act 2022. So whenever you are citing a provision of the law or a law itself, ensure you cite it correctly and completely with the year. So we also have the Nigerian Medical Association. Yes, it does not regulate, they do not regulate healthcare contracts. No. It is an association of healthcare practitioners who come together to sharpen their skills, one, remind themselves of the ethics of the profession and how to carry on, but it does not. What of medical ethics? This is why I said it would have professional code of conduct of the respective healthcare professionals. Now, the nurses, the pharmacists have their radiographers, anesthesiologists have their and all that and all that and all that. So it's not just medical ethics. Then also the option terms of contract. What categorization
there is the express term of there is the implied term of the express terms are those terms that are written in black and white that the parties sign. But here are the implied terms which are not written, but by using of the written or express terms, those implied terms. For example, if required to descend into now, except where it is expressly written that you continue to work. You understand? Patients, here, patient engages a doctor. Even though the contract is not written, there is an implied term that the doctor will treat the patient with reasonable skill and care of a healthcare practitioner of his standing. No patient will know that this healthcare provider or healthcare professional does not have the qualification to treat me and submit some treatment. I heard a chilling story today this afternoon when somewhere and the person got to know that the medical expert and share his story when I said so we stood at the center hospital. There a lady went and the doctor who is an oncologist. Once the lady extract some lumps, sample from lumps for tests, because he's not a specialist in that field of medicine, before they get the decision he made on the girl. Another person
Sir, we can't hear you, sir.
Hear me. So, can you hear me now? I've removed my AirPod. Can you
Yes,
hear
can
me
hear you
now?
now. Yes, sir.
Okay,
Loud and clear
awesome.
now.
Please, where did you lose me? What
Okay.
was the last thing you heard?
Good afternoon, sir. The last thing I could hear
Yes.
was on the bodies and laws that regulate healthcare contracts. After that, I couldn't hear anything.
That's long now. I have spoken for almost 2 minutes after that. Please, next time, immediately you can't hear, indicate, please. Okay. After discussing the bodies, that these bodies do not regulate a healthcare contract. Contracts generally, whether healthcare, if it is a contract, it is a subject of interpretation by the courts. Do you understand? Even where parties cannot by themselves hoist the jurisdiction of the courts. So even where parties put dispute resolution mechanism and they say we will submit ourselves to alternative dispute resolution, either mediation, conciliation, or arbitration, no party should go to court. We will explore alternative dispute resolution. The courts have ruled that parties cannot on their own hoist the jurisdiction of the courts. So contracts generally are subject of interpretation by the courts. Then I talked about terms of a contract, and I said that there are basically two broad categorizations, the express terms and the implied terms. That the express terms are those terms that are written boldly in black and white, that document you have, which the parties sign, and that the implied terms are not usually written, but they are implied and take their root or their life from the express terms. For example, not all contracts are written. Not all contracts are formal. There could be oral contracts or oral agreements. So when a patient walks into a hospital to meet a doctor, there is a contract, but that contract is not written. So when the patient presents himself for treatment and the doctor accepts to treat, there is an implied term that the doctor will treat the patient with utmost care and skill of a healthcare professional of his standing. That was what led me to the story I was sharing before I received a notification that I wasn't being heard. I said today, this afternoon, I went somewhere, and when the person got to know that I'm into patients' rights and safety advocacy, the person now made a complaint that in a particular hospital, a doctor went to cut a girl, make an incision to extract breast lump samples with which to test whether it was cancerous. Unfortunately, that doctor was not a trained oncologist. He had no business treating cancer patients, but he went to cut this girl. And they are saying that the incision, the cut he gave on the girl's breast, never healed for more than 1 year. And eventually the girl died. Now, that is not only medical malpractice, because the girl, the doctor had no business treating the girl in the first place. He was not staying in his area of specialization. What he ought to do is to refer the girl to an oncologist who had the expertise. But why I'm sharing this is that the girl, part of her contract was not that a doctor should make an incision on her that will not heal. That was not part of our terms. So there was an implied terms that you are a qualified doctor, you will treat me professionally and give me quality healthcare service as required or as expected of a doctor of your standing, of your professional standing. Do you get that? So there are express terms and there are implied terms. Then other things you need to know about contracts is representation and misrepresentation. Representations are the things you say when you go as a healthcare professional and you say, I have 10 years experience in gynecology. I have practiced as a cardiologist for 15 years. Those are representations you are making. And it is based on those representations that your would-be employer engages you, believing you that firstly, you are a qualified healthcare practitioner. Secondly, you have this level of experience you claim to have. Those claims you are making are representations. Then any of those claims, if it is found to be false and misleading, it is called misrepresentation, meaning that you lied. And contracts could be vitiated because of misrepresentation. If you said you trained in US, whereas you trained in Nigeria, it is misrepresentation. If you say you have practiced medicine for 15 years, whereas you have just practiced medicine for 4 years, it is misrepresentation. Even if you became a doctor 15 years ago, but when to do buying and selling. You have not practiced medicine for 15 years. Then after 4 years, you just came back into the system and started. So if you say you have practiced medicine for 15 years, it is different from I have been a medical doctor for 15 years. That you have practiced medicine for 15 years is that you have been seeing patients, treating them, making diagnosis for the past 15 years. Then I've talked about the presentation. I have talked about misrepresentation. Then we now talk about remedies available. Okay, common challenges with healthcare contracts and transactions. You omitted non-compliance with regulatory and legal requirements, fine. A lack of adequate communication between the parties, okay. Payment disputes, yes. Lack of clarity as regards the kind of service to be rendered or received, unclear or ambiguous terms of contract, terms in the contract, fine. Now, the most important in all this you have mentioned is either deliberate refusal to engage the services of a lawyer, a qualified, experienced lawyer. Contract drafting is the job of a lawyer. But because it is written in English language, most times we see people who feel, because I can speak, read and write English, then I am qualified to draft a contract. Sometimes it is not so. So when those contracts are drafted by persons who are not lawyers, they tend to mumble the terms and just put everything upside down and they sign. And it is only when there is trouble that they now run to a lawyer to say, this is my problem. It is not only with healthcare contracts. Almost every people enter business, people buy land, people rent house. They don't engage the services of a lawyer until there is problem. People sign all manner of documents until there is problem. Then you now bring it to a lawyer, which is actually the first thing you should have done before you sign. But because we want to save money, at the end of the day, we end up spending more than we budgeted in litigation, trying to correct a mistake we should have even avoided in the first place. So one of the major challenges is refusal to engage legal practitioners, experienced legal practitioners. So your scope, mitigation of the common challenges, fine. Define the scope, include payment terms, clearly outline responsibilities of both, include dispute resolution, ensure that the contract entered into is in alliance with provided existing law, ensure that contract should be signed, you omitted is signed by both parties. Okay, why this is good, I will reiterate what I just said. Engage, employ the services of a legal practitioner. If you are given a paper, a document to sign, it is not weakness. It's not weakness to say, let me give it to my lawyer. What it means is that you acknowledge your limits. Now that document is written in English. The duty of a lawyer, as he's looking at the document, he's working, he's thinking with the mind of the court. The interpretation the court is going to give the wordings of the contract. All of you are aware of the ongoing Presidential Election Tribunal. Why are they in court? To interpret the meaning of and FCT, 25% in 36 states and FCT. Okay, what does and mean? Does it mean FCT is included, is required to get 25%? Does it mean FCT is excluded from having 25%? That's why they are in court. to interpret and. So, if it was not important, the over 20 senior advocates that are involved in this case for the different parties will not be there. So the duty of the court, yours as a party to an agreement, is to read, probably understand to the limit of your knowledge, but interpretation belongs to the court. And the closest person that will give you the mind of the court is the lawyer, because he has been trained in that regard. So beyond healthcare agreements, whenever you find yourself entering any agreement, look for a lawyer to interpret it to you before you sign. Don't assume that you have understood it because it is written in English. There is more to legal interpretation than rules of grammar and English language. Then we talk about remedies. Yes, damages. Fine. Specific performance is there. What is specific performance? That we have agreed you will pay me maybe 1 million naira at the end of the month. If I do this, fine. Before I continue there, conditions. We have condition precedents. These are also terms you should look out for. Condition precedents. If the condition precedents are things that must happen before another happens. For example, if the contract says you must have attended, you must have been in the office for 28 days in a month before you will be paid your salary, that becomes condition precedents. It does not matter whether you came to the office for 26 days or 27 days and you treated 100 people within that 27 days. The contract says you should attend work at least 28 days in a month to be entitled to your salary. That becomes condition precedent. Meaning, if this does not happen, this one will not happen. So it's also what you should look out for. Are there condition precedents in this contract? Now, another condition precedent could be qualification. Okay, we are going to employ you on the condition that in the next 7 months, you would have qualified for this and we will start paying you X amount. So if in the next 7 months you fail to qualify to get that particular certification, it is a condition precedent for you to receive your full salary. So if you now come and say, they have not given me my full salary, and you rush to court, the court will point you to the condition precedent in the contract you signed. So that is that. We talk about specific performance. Specific performance simply means perform your obligation under the contracts. If you say, okay, at the end of the month, we are going to pay you 500,000 naira, and the month ends, and this person has worked in your hospital, and the month ends, and you now say we are going to pay 350, or we have 400, or we have 200 to pay, and you do not give sufficient reason why you should take it, and you are saying we are paying you 200 as full and final payments. If the guy goes to court, the court will order for specific performance. Provided that he is not in violation of any condition precedent, he will get his money. So specific performance is the court ordering the party in breach to do exactly what his obligations are under the contract. Then we have injunction. Injunction is where a party is doing what he's not supposed to do in the contract, and the court now says, hey, that thing you are doing is not part of the contract. The issue an injunction, it could be restraining injunction. Restraining you, stopping you from doing what you are doing, which you are not supposed to do. Do you understand it? Hello? Hello?
Yes, sir. Yes, sir. We are on the
Yes,
call
sir.
and we understand.
Okay. Then we also have rescission.
Receipt transfer.
We also have
5,000.
rescission.
5,000.
Now, rescission is like cancellation. You rescind the contract. Assume the contract never existed. The court will nullify the contract. That's the party who has been offended or whose right is being trampled upon.
That is now 100
Please,
naira.
the person whose microphone or should mute it. Participants, please mute your mic. Hussein, mute your mic, please.
I say I
Hussein,
want
mute
to do
your mic.
transfer.
Hello, Hussein. Mute your
Okay,
mic.
sir. Okay, sir.
Your background is affecting us. Okay. So we have rescission, which is that the contract is nullified. The contract is cancelled. If there is fraud and you have done what you have done that requires this person to do something, but the person cannot do it because you have not done what you are supposed to do, the person stands a chance of rescinding the contract. For example, a doctor enters a contract with the hospital and the hospital do not have certain equipment, and they specify in that contract that within the next 1 year, we would have done this, we would have provided this equipment, we would have built this laboratory, we would have done this, we would have done this, we would have done this to enable you carry out your work effectively and efficiently. Then after 1 year, the hospital have not done what they are supposed to do. The healthcare practitioner can rescind the contract. If he goes to court, or if the hospital sues him, the court will uphold that right or that decision of rescinding the contract. Then, of course, damages. Damages are more like compensation for loss incurred as a result of the breach of the contract. So, and there are different types of damages. Now, damages mostly are monetary compensation. So you have exemplary damages, you have general damages, you have special damages, you have exemplary damage, you have punitive damages. So you can claim under different heads of damages. You can claim punitive and exemplary damages. What is it? The court is awarding $10,000 against this hospital to serve as a punishment to them and also set example to other hospitals so that they do not sign or treat their contractors this way. General damages, because I have suffered this and this and this and this. Now, general damages come from the legal maxim that where there is a wrong, individuals should be remedied. Where there is a wrong, there is remedy. So what remedy am I entitled to? Damages. The hospital or this other party to this contract has wronged me. So I am entitled to damages. You now see that even in medical negligence claim or healthcare malpractice claims, part of what the patient gets sometimes is damages too. The wrong has been done to you. This. So if there are questions, I would like to entertain them at this point. Thank you very much. Hello. Do we have
Hello,
questions?
sir.
Okay.
Yes,
good.
sir. We have questions. I just posted the questions on the chat box. But where I am is really noisy. I don't know if you can just access the questions.
Read the questions out. Read the questions out.
Okay, question
Or
one
someone
says,
else can read it.
question one says, what
Hello?
consideration should be made? Can you hear me, sir?
Yes, go ahead.
Okay. Question one says, what consideration should be made when engaging in transactions with healthcare providers or organizations outside of your country jurisdiction?
Okay, outside of your country's jurisdiction, firstly, you check the law that we govern the transaction. You check the law. If you are in Nigeria and you are entering a contract with somebody in the United States, it is part of what you will determine in your contract. This contract shall be governed by XYZ law or the laws of XYZ country. So if you want Nigerian law to govern it, you specify. For example, if you are talking arbitration, you can say that this contract will be governed by the provisions of the Arbitration and Mediation Act of Nigeria 2023. You put it there. That means in the event of dispute, it is the provision of that particular law that will govern your agreement. So that is it. Firstly, you have to check the law you want to govern your agreement. Did you get that?
Yes, sir, we got that, sir.
Okay.
I want to read the next question.
Go ahead, please.
Okay. What are the key elements of a healthcare contract and how do they differ from contracts in other industries?
Okay, how do they differ in contract from other industries? Basically,
yes.
The elements of a contract are what have been enumerated: offer, acceptance, consideration, capacity to contract. Now, intention to observe, intention to enter legal obligation. Intention to enter legal obligation. So you cannot have a contract and not intend to be bound by it. So that is also one element that was missing in this work. Intention to enter legal obligation. So you cannot sign a contract and not intend to be bound by the contract. Do you understand it? So generally, elements of a contract, there must be an offer. Somebody is making an offer. There must be an acceptance. This other person is accepting. There must be consideration. What value are we exchanging? Is it service for money? Is it service for service? What value are we exchanging? What am I paying you? What are you getting in return as a result? If someone is selling his land for 10 million naira, the 10 million naira becomes the consideration for that sale of land contracts or agreements. Now, if somebody is being paid 1 million naira per month, that sum of money becomes a consideration. Now, there have been cases where people work and the establishment train them in school. That is consideration. That while we are working here, in return to you, we are going to take care of your education or to build your capacity in this area. So there must be an exchange. That is consideration. Then capacity to contract. She has already mentioned it. If you are not a minor, if you are not a person of unsound mind, you are qualified to contract. But if you are among the persons who are not qualified, then you lack legal capacity to contract. Any contract that is entered by such a person who lacks the capacity is void and deemed not to have existed. Then intention to create a legal obligation, meaning that once you enter this contract, I expect or intend to be bound by this contract. We didn't come here to play pranks. We didn't come here to play pranks. So that is it. Now, if you are talking about what's the difference between healthcare contracts and other contracts, basically the subject matter. The terms of a contract, I mentioned scope of service here. We mentioned non-disclosure. We mentioned non-circumvention. We mentioned now for scope of service. Engineering contract, we also have scope of service. But you now see that the service to be rendered in engineering contract is different from the service to be rendered in healthcare contracts. The same thing with building contracts. The same thing with car manufacturing contracts. There's always a scope of service. So the major difference is the subject matter of the contracts. This is health related. So we will be talking about patients, we'll be talking about healthcare equipment, we'll be talking about qualification of the healthcare personnel, we'll be talking about their remuneration. Now, if it is maybe computer development contract, we might be talking manufacturing contracts. We might be talking about date of delivery. We might be talking about specifications of the car, how many tires we want to have. We might be talking about the interior design. So the major difference between healthcare contract and other contracts is the subject matter of the contract. That's the major difference. So all the terms, all the elements of contract apply in all contracts, all valid and legally binding contracts. So all the elements of a contract applies. The terms of a contract, express and implied terms, they apply. Now, it is now the conditions you people set out. You will always have a clause that says, now this contract witnesses as follows, or that these parties, both parties have agreed to enter this contract based on the terms and conditions stipulated hereunder. Then you begin. One, that Mr. A will resume work at 7 p.m. That Mr. A will quit his former job to take up this job. That Mr. A will commence working here from the first day of August 2023. And all that. Then you now state that Mr. A is entitled to so amount as remuneration. And you continue. When you put all those clauses down, at the end of the day, you sign. So your specification, the clauses still apply in other contracts. So you still have duration, you still have commencement. There you might be talking about time of delivery. Here you still have a non-disclosure. Even that one, you still have non-disclosure because it has to do with design. You will now talk about intellectual property protection. So you now talk about non-circumvention and non-disclosure. You now talk about what type of information should not be disclosed. We talked about non-disclosure there. Here we are talking about the patients and their information. Here you are talking about the design and the specifications of the design. You are talking about trade secrets there. So it is basically the same, but the major difference is the subject matter per time. I hope the answer is clear. So
yes, sir, it's clear. Okay, the third question is, what are the most common types of healthcare contracts and transactions, and what purpose do they serve?
Whoa. The purpose of contracts is for ease of understanding. Simplicity is written in black and white. If we enter a healthcare contract,
I don't like that one. Sorry. I think it was sorry.
Tomorrow, if there is a dispute we do not have written terms. It will be my word against your word. So the purpose of contract is for definiteness. There is a boundary of scope. It spells out my obligation. It spells out your obligation. It reduces dispute among the parties. Because if it is only word of mouth, I can wake up tomorrow and I forget that I am supposed to do this. Now, when you remind me, I say, no, it's not my obligation. But if you have it written down in the document and signed by me, you can quickly flip through. Do you understand it? So that is the purpose of a contract. For definiteness, it makes understanding easy, even for ease of dispute resolution. For example, you have included in your contract that in the event of dispute, you refer the dispute to an arbitration panel. In fact, some contracts will specify each party will appoint arbitrator. Then in some contracts, they say each party will appoint an arbitrator, and those appointed arbitrators will jointly appoint a third arbitrator. Some will say arbitrators from multi-door courts. Some will say arbitrators from chartered institute of arbitration. So it specifies steps to be taken. But if it is word of mouth, my word against your word, it ends there. So that is it. Next question, please.
They know they talk and where the head say you don't fit. They go try you, bro. I'm trying to tell you.
Sir, can you hear me, sir?
Yes.
We don't have any other question. I'm encouraging our mentees to ask any live questions. We don't have any other questions. Live questions, you can take live questions. And while we are taking live questions, I encourage everyone to turn on their video so that we can quickly take the screenshots for today, the picture time. So I'm waiting on our mentees on the call to turn on their videos. Thank you very much. To do so. See Agbo, Cynthia, and Evie ask now.
Now we are just while away the time, you understand? There are some things. You know, as a Yoruba,
sorry, I'm on transit and my environment is really noisy. Okay, I've taken the screenshots. So I think we've come to the end of the session for today. I don't know if you have any final comments for our mentees before we go.
Today is week 4. I want to salute your consistency. In no time, you will be done with this program. I will encourage you to introduce it to your friends if you have found it worthwhile. Then, secondly, beyond taking medical law, there are other courses too. Take them, go to data protection, go to fintech, just broaden your knowledge. And most importantly, the things you have learned here, put them into practice. And finally, study. There's always room for improvement. So thank you very much.
Okay, sir, somebody's hand is up. Evie, I think we have a live question.
Okay, Evie, let's hear you.
Okay, good evening, sir. Good evening, everybody. So my question, I wasn't really quite...
Can you turn on your camera?
Okay. Yes, good evening, sir. So my question, I wasn't really quite clear on 2 things. The first one is that we talked about parties not being able to oust jurisdiction of the court just because they put particular dispute mechanism in one.
Yes.
I'm clear on that. Is it that they don't automatically go to, in the event of a dispute now, they cannot automatically resort to the mechanism they chose in the contract. They have to first take it to court. I don't really understand that
Okay,
well.
that's what I mean. Okay, ask your second question.
Oh, okay. Thank you, sir. So my second question was still on that that question we asked about contracts with persons outside Nigeria and the applicable laws. Contracts with persons outside Nigeria.
Now, you see, one thing about law, first thing, let me start from your second question. One thing about law is that law is jurisdictional. The things that are applicable and obtainable in Nigeria may not be applicable and obtainable in the US. Obtainable in the US. They might not be applicable and obtainable in China. So to save yourself, you determine from inception that this contract shall be bound or shall be governed by laws of the Federal Republic of Nigeria or laws of the Republic of China or laws of the Republic of whatever country. That is one. So once you determine the jurisdiction, now, why is it important? In some countries, they might tell you that, okay, for in Nigeria, I think for contracts, breach of contract, for you to bring the case to court, it has to be within 6 years. So if you have had breach of contract and you come to court 10 years after, your case is already statute barred, meaning that the case has expired. You cannot get any remedy. Your case is already statute barred. For example, medical negligence cases come to court within 3 years. If you bring your medical negligence case after 5 years, it is already statute barred. Even though the court will want to interpret to count 3 years from the time the complainant became aware of the negligence. But if you are aware from day one, now, these things are not written on the streets. You now see why I said it is important you engage a lawyer to interpret for you before you sign. So if in Republic of China, their own law is that a contract goes to, a breach of contract case goes to court within 6 months. And you say your contract is to be governed by the laws of China. Then you waited for 2 years before going to the court. You will see that that document, that contract, you cannot get remedy because it is already statute barred. So to be safe, if you are entering a contract between your jurisdiction and another jurisdiction, specify in that contract what law you want to govern the contract. It is always safer to take the law you are more familiar with. You are a Nigerian, you know how Nigerian law operates, you know a lot of Nigerian lawyers. So if you say this contract will be governed by the laws of Nigeria, then if anything happens, you can go to court here. But if you're in Nigeria and you enter the contract with someone in France and you sign that the contract will be governed by the French law, when the time comes, you are obligated to fly to France to go and file your case. Then when you get there, they are going to give you their law in French. You have to go through the rigors of getting an interpreter if you do not understand French. You see the complication? So it is always safer to use the law you are familiar with. Even in the Nigerian law, for arbitration, they make it clear to say this because there are other alternative dispute resolution mechanisms. Conciliation is one. So it is not just sufficient to say this law, this contract, in the event of dispute, the parties shall resort to alternative dispute resolution. You have said nothing. That is ambiguous. What alternative dispute mechanism are you talking about? Is it mediation? Is it arbitration? Is it conciliation? Is it med-ab? Is it ab-med? Which one? So you now specify that the parties shall resort to mediation. Each party shall appoint a mediator, and the appointed mediators shall jointly appoint a third mediator who shall chair the panel. Each party shall bear the cost for his mediator, and both parties shall jointly bear the cost of the third mediator, the chairman of the panel, in equal proportion. Full stop. So a party interpreting follows this step. Now, this is condition precedent. I'm coming to your second question now. This is your first question. This is condition precedent, that in the event of a dispute, parties shall first explore alternative dispute resolution mechanism, i.e. mediation, i.e. arbitration. Some even specify where the arbitrator should come from. Some can say the arbitrator should be appointed from Lagos State Multi-Door Court or from FCT Multi-Door Court, or there are arbitration institutes. Like I say, from Institute of Arbitration, Nigeria. Some can say from Chartered Institute of Arbitration, United Kingdom. That's where you go and bring your mediators from. Some can even put venue of the mediation. I say, in the event of a dispute, parties shall explore alternative dispute resolution by mediation, with the venue to be at Dubai. So when there is dispute, parties will appoint their mediators and everybody flies to Dubai for the settlement. Do you get it? Now, why I said that parties cannot by themselves hoist the jurisdiction of courts, I mean that in your agreement, you cannot write agreement and say where there is a dispute, no party is allowed to go to court. You can't make so, you can't put such a clause in your agreement. By saying no party is allowed to go to court, you have hoisted the jurisdiction of the court. The court is there to protect everybody. You can say where there is a dispute, parties shall first explore alternative dispute resolution. Then where a party is dissatisfied after this process, that dissatisfied party can go to court. But you cannot write an agreement and even sign it that where there is dispute, parties are bound to use alternative dispute resolution and none of the parties shall go to court. Then eventually, one aggrieved party now goes to court. You now bring up the agreement as a defense and say, my lord, we signed that no party shall go to court. You are trying to oust the jurisdiction of the court, and the law is saying that you cannot do that. Do you understand? Okay, awesome. So next question, if there is. Any other question? Okay, so Mr. Hussaini, over to you. Is he still there, Mr. Moderator? He has gone out. Okay. Okay, ladies, now I happen to be the only gentleman here. Okay, so ladies, I think we shall be ending the class today. Do have a wonderful and fruitful week. So, all the best. Goodbye.
Thank you, sir.